from the appellant.
Good afternoon, Your Honors. Good afternoon. May it please the court, my name is Andre Wharton on behalf of the estate of Barbara Pinson. This is in the conservatorship of Annette Cross. Please, court, is my understanding we have 15 minutes. I would ask to reserve 5 minutes for rebuttal. I know that I have two learned counsel on the other side, so I need adequate time to respond to both of them, Your Honor. So I ask for 5 minutes. Your Honors, you all, and just looking here before we got started, I looked at the box, and you all have probably already observed that this is a voluminous record, relatively speaking. I know, Your Honor, Judge McGee authored the first opinion, I believe, in this case concerning this conservatorship of Annette Cross, and so I will try my best, endeavor not to be redundant or repeat facts that are contained in the original opinion, but I think it's important to point some facts out as I go through my argument this afternoon. And there are basically 3 points I want to address with the court. The first being this Rule 60 issue concerning jurisdiction. That's the first point I want to discuss. The second point is the issue of equity and why equity in this case necessitates that the court should have granted our Rule 60.02 motion. Thirdly, there's a due process issue that's readily apparent from this record and from the procedural background and what transpired at the probate court below. So I'll try to take it in that order. Before I jump into my argument, we're not here today, respectfully, to talk about Barbara Pinson and the length of time that various things took to get justice and what transpired below and how many times, I suspect you'll hear how many times this case has been on appeal and that we've been here before and that a Rule 11 was filed. You'll hear those things. But I think the issues, as I've outlined them today, are really the salient issues that I would ask this court to focus on for the purpose of the type of relief we're seeking in this appeal. So the first issue that I intend to discuss today is this issue of the judgment being void for want of jurisdiction. I think it's pretty clear, and I think the Harris versus Hall case discusses this issue. There are other cases we cite, but I want to start there. The Harris versus Hall, you all are familiar with the Ware versus Meharry case. The General Sessions Court lacked jurisdiction in this case to grant the relief it granted. To give you all a little background of why we're here, I think the important thing to point out for the jurisdictional issue is Circuit Court in November of 2020 set aside a judgment that emanated from General Sessions, went on appeal to Circuit Court. This court, in Judge McGee's opinion, referenced at least twice, and we cite this in our brief, and I'm paraphrasing, but in essence, notwithstanding the jurisdictional limitations in General Sessions Court, acknowledging the limitations of the jurisdiction in General Sessions Court is mentioned twice in Judge McGee's opinion. That is important because this court may ask, why are we back here? Well, after this court rendered its opinion on the first Annette Cross estate, the conservatorship, the case went back, the Rule 60 was heard. The Rule 60 was alluded to in Judge McGee's opinion. That Rule 60 has been heard and was heard after this court rendered its first opinion, and the Rule 60 was granted in my client's favor. What Judge Wagner did say, however, was that the General Sessions judgment remained in effect. Even though she set her Circuit Court judgment aside, the General Sessions judgment remained in effect. I suspect opposing counsel will point that out. That still does nothing, and we cite the Blackburn case, and we cite numerous cases. That still does nothing for the fact that we're properly before the court on the Rule 60 and that a jurisdiction issue can be raised at any time, whether in the trial court or before this court. The analogy used sometimes is a tree with dead limbs. It can't be resuscitated. If it's a dead tree and never was alive, if it was dead, as they say, void ab initio, then you can't resuscitate something that never lived, if it just never gave birth. Our argument is that the General Sessions Court lacked jurisdiction from the front end. Give you all a little factual background. Mr. Cleveland Gibbs was the son of Teresa Gibbs. Those are the two we submit and contend are the bad actors in this case. There's a lady by the name of Verlie Cunningham Harris started a trustee, established a trust. The trustee of that trust was Appellee's counsel, their client, Miss Teresa Gibbs. Teresa Gibbs was a trustee of that trust, and the benefit of the trust was for one of the persons was Annette Cross. My client was a beneficiary of that trust. She was one of the three daughters. You had Teresa Gibbs, you had Barbara Pinson, and you also had Annette Cross. Our contention was when this property, that's essentially what we have before the court. That's the issue here. Trust property was sold for the paltry sum of $78,000. Teresa Gibbs sold that to her son, Cleveland Gibbs, for $78,000. The property was appraised, and this is all in the record, the property was once appraised for $2.2 million. So the question may be asked, well, why are we back here? Well, if you look at the Alexander versus Nelson case, there was a discrepancy or a variance of $48,000 to $22,000 or somewhere thereabout. We're talking $2.2 million to $78,000 comparison, a mother selling property to her son. So that's one reason why we're back here, and we'll deal with that in the equity portion. But moving on this jurisdictional issue, and we've established this and discussed this in our brief, the West versus West case, I think, is very instructive for this court. This came out after Your Honor's ruling initially on the first case. The West case talks about jurisdiction and limitations in General Sessions Court, which frankly Judge McGee acknowledged in the first opinion. And what West said basically was when you have an unlawful detainer, which we contend, when Cleveland Gibbs filed the action against my client Barbara Pinson and Denise Pinson, they were, he alleged, we submit, they were tenants in his property that he bought from his mom, ostensibly, and he attempted to evict them from the property. We submit, and the action was filed as an unlawful detainer action. Well, General Sessions can deal with unlawful detainers if it's properly before the court, and we submit there was no contract here, and that's what West talks about. If there's no contract, that court lacks jurisdiction. In addition, and I suspect this will come up, the appellees argue that the Boyce case, and the court cites, frankly, and I want to take this opportunity because I'd ask this court to really distinguish Boyce in this case. Our case is not a Boyce case. Boyce versus LPP Mortgage, Boyce versus LPP Mortgage, LTD, 435 Southwest 3rd, 758. And the appellees spend an inordinate amount of time speaking about Boyce. Boyce controls. Respectfully, Boyce is distinguishable and doesn't control the fact pattern in this case. Boyce basically said these issues of title can be raised as a foreclosure defense. It can be raised as a defense, but what prevails is the language in statute, the language in Ware, the language in West, and numerous cases that say matters of title shall not be inquired into in General Sessions Court. General Sessions does not have jurisdiction to deal and decide title issues. You can raise them as a defense, as Boyce indicated, but that's not what was done here in this case. In effect, what the appellees are arguing is that the General Sessions Court can start engaging in Chancery Court type jurisdiction or probate court. And the law, statutorily, the law based on West and numerous cases, Ware versus Meharry, says the General Sessions Courts cannot go that far. And
let me ask you this, I can't cite you to the cases, but I'm just reflecting back when I was in Chancery, and I know it was at a time when we were having a lot of these foreclosure cases coming into the court, and it seems like there's a long line of cases that say that title is decided in the General Sessions Court, and that if it's not raised in the General Sessions Court, then it's waived. I mean, and it came up in almost every one of these foreclosure cases as to who actually owned the property, who was the owner, and in most of those cases it was never raised in the General Sessions Court, and so it was effectively waived. Is this what we're talking
Chancellor,
about?
I'm familiar. I mean, I'll take you back when you said Chancery. Judge, you're correct, and I think that's what Boyce dealt with. You have to raise it. I think you pointed out the really distinction in Boyce that I want to emphasize for this court. You need to at least raise it, or it's potentially waived. In this case, we didn't have that issue.
I mean, if it's not raised,
correct,
it's waived.
Correct. In this instance, we did have it raised. And I wasn't counsel at the time, but the counsel for my client, at that time, she was not the estate, she was still living. They were attempting to remove her from the property. Barbara Penson's counsel, Denise Penson was her daughter, raised and waved the flag of, hey, we need to take this case to probate court. There's an action going on that needs to be heard.
But I thought what you said was that the General Sessions Court could not decide that.
The General Sessions Court, and I think it was alluded to by inference or implication in Judge McGee's first opinion, the General Sessions Court can't consider those issues in terms of defenses. But my argument is that the jurisdiction has not been conferred upon General Sessions to start delving out title or you own this. They can look at it in terms of defenses. But my reading of Boyce and cases that are contrary to it is that it's limited to defenses. You have to raise it or else potentially waive. That was not what was done. This was not just a defense. This was an offense, if you will. My clients at the time were attempting to say, hey, look, we own this property. You didn't do this right with the trust, and therefore they're bringing in action, not defending it.
Well, let me ask you to take it to the next step. In other words, once it's raised in the General Sessions Court as a defense, what happens to it then? I mean, does the General Sessions Court not have to decide it, to decide that
I think
issue? Or, I mean, they can't just say, well, you've raised it, and so therefore I can't proceed.
Yes. Well, here's what they can do. They can look at it in terms of a defense, and then they can decide whether possession is proper to be granted or not. But I think the proper action in here, and it's amazing, it's so ironic, the previous case I think just dealt with the transfer statute. That's what the proper action, a motion was filed here to transfer the case, and that motion was denied. And we cited this case called the Haynes versus Rutherford case. Then we submit that's important because it told, our argument is regarding statute of limitations issues and those things, when that motion was filed to say transfer it to the right court, this was not transferring to another case action, transfer it to the right court, i.e. probate. The General Sessions Court should have stopped. What the action should have been, not even consider the possession. Transfer and say, wait a minute, there is something going on that involves a court that can really decide the substantive issues, not only defense issues, but also your case that you're attempting to prosecute. Let me transfer it over to a court that does have jurisdiction over it. That did not happen here.
Well, you still have a de novo appeal to circuit court.
You ask a good question. And I think Judge McGee raised that. Now, there was an appeal to circuit, but in that instance, what happened here is the circuit court judgment, post the appellate court's opinion in this first case, was set aside, taking us back to General Sessions, and we submit the action of the General Sessions Court judge, which is at issue now in this case, was void. It still is void. It's never going to become unvoided. And therefore, by the filing of that motion, the matter should have been transferred and the matter should have been litigated there. And I think that's where all this starts and really should end as far as this court's decision. I know I'm into my other time. There are other issues, equity, not to minimize the importance of it.
You'll have your rebuttal.
Yes, sir, absolutely.
Thank you.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
I'm Alton Wade. I represent Teresa Gibbs. Mr. Townley represents Cleveland Gibbs. We got together and drew a play in the dirt. He's going to take 5 minutes, and I'm going to take the first 10.
First 10?
Yes, Your Honor. I don't know how to address this. There are 3 issues. We've raised one issue on cross appeal, which is a request for attorney's fees for prosecuting a frivolous appeal. I will submit to the court that there are 3 main issues. One is the Rule 60 motion that's been challenged, the decision of the probate court to deny that. The other is the award of attorney's fees to Ms. Gibbs for pursuing the execution on her judgment that was sustained in Judge McGee's opinion. And the third is the one I just mentioned, is the request for attorney's fees for a frivolous appeal. The one thing we dwelled on is this General Sessions matter. The first case was decided based on summary judgment based on 2 issues. One was the failure to bring a proper claim for breach of trust within the 1-year statute of limitations under 3514-1004, I believe. That was dispositive of the request to set aside this sale of property from my client to her son. that was alleged to have been a breach of trust. Though all of these equitable issues that are being raised and unclean hands and all of these things are subsumed within that cause of action. That cause of action is dispositive of the whole case, irrespective of what you decide or even hear about the General Sessions issue. The General Sessions issue was a second and separate cumulative reason why you could deny the request for relief, because it was deemed to have been res judicata, where Mr. Gibbs, after acquiring the title, sued for possession of the property in General Sessions Court. There was no defense raised about title in his client. The judgment was actually rendered in favor of Mr. Cleveland Gibbs for possession. That was purported to have been appealed to the circuit court by the two tenants in possession, and that was Barbara Plinson and her daughter. The circuit court, Judge Wagner, ruled, however, that Barbara Pinson's appeal was invalid because it was signed by her daughter and not by her, and her daughter was not a lawyer and not authorized to represent her mother and file that appeal. Judge Wagner then ruled, however, that because she didn't appeal, the General Sessions judgment was final as to her, and therefore it was never appealed, and it has never been appealed in 10 years. So you have multiple statutes of limitations that preclude Barbara Pinson from ever recovering on that property. The Rule 60 motion we submit after Judge McGee's opinion was filed in this case. My client executed on a judgment that was rendered for attorney's fees in the first action. The Pinsons moved to stay that. They moved to set it aside. They filed all post-judgment motions. They filed the same motion in this court when it was on appeal before this court, and also filed another motion in the Supreme Court for the same relief. This court declined to stay the execution because of the opinion that had been rendered and fully dispositively decided all issues in the case. The Supreme Court ultimately, in its mandate or in its denial of permission to appeal, refused to address that issue either. But after all of that, the Pinsons continued to prosecute and frustrate my clients in the execution of her judgment. Execution of judgments is basically an extrajudicial process where you ask the clerk to issue a writ to be served on someone in possession. That can be stayed simply by posting a bond. They didn't do that. In essence, what they did is went into this baseless litigation to try to do everything they could to forestall my client from executing. The Rule 60 motion was that vehicle. The Rule 60 motion basically, and I want to quote Judge Webster, who said the Rule 60 motion filed in the context of this case is unknown to law. And essentially what it was a Rule 60 motion to ask for relief from Judge McGee's opinion and judgment. And that was ultimately affirmed by refusing to hear it by the Supreme Court. So they were asking the trial court to give relief against an appellate court opinion. And Judge Webster said, that's unheard of in the law. We found there are a couple of cases where that's been tried, not many. I mean, I never heard of it before. I never heard of a trial judge overruling an appellate court opinion, but I would confess I found a lot of things in the appellate decisions that I've never seen before either. But there are cases, and there's one, I think, an opinion issued by now Justice Kirby, which basically says that if you come back for Rule 60 relief on the same facts and circumstances that were just decided, that case that was just decided becomes precedent or the law of the case, which would preclude you from getting Rule 60 relief. It is so obvious that not many cases decide that. So it was our position that the action to forestall my client's execution on the judgment was baseless. It was causing her to have to incur additional attorney's fees unnecessarily. It was inequitable. There was no factual basis for it. Judge Webster handled it appropriately, exercised her discretion appropriately. She applied the correct legal standard. She referred it to a special master that also decided that this action was not appropriate. So we believe that the record is sufficient to sustain the award of attorney's fees on the second award of attorney's fees. We also believe, and if you would just bear with me, I think we've addressed all of this in our brief, but these factors, I think, summarize why we think why we're here is unfair. Appellants failed to provide any legal, factual, evidentiary support for the claims and contentions in its post-judgment stay quash motions against my client. Appellant's prosecution of unnecessary post-judgment stay motion when they could have only posted a bond and gotten a stay, which would have protected my client, because if they failed, I would have been able to execute on the bond and get immediate relief. They continued to pursue these matters even after the Supreme Court decided that they were not going to entertain a further appeal, and it became final and this court issued a mandate, and they continued to litigate the issue. The unfairness of burdening my client to spend her money to defend her actions, which were completely lawful, and the ability of appellant to pay the judgment, which is based on evidence in the record that the estate has assets which are probably 10 or 15 times greater than the amount of my judgment, and the prevailing party concepts, which we ultimately did prevail in the trial court. We think all of these factors justify the second award by the trial court, and also an award by this court for a frivolous appeal, because we don't see any legal basis for how a Rule 60 motion can be sustained based on law of the case and res judicata principles. And with that, I'll defer to my co-counsel.
Thank you.
May it please the court, Richard Townley of the Shelby County Bar for Cleveland Gibbs. Mr. Wade stole some of my thunder on law of the case, but my argument is fairly simple, which is that the prior opinion of this court in this case is binding not only on the probate court below, but it's also binding on subsequent appeals. And so respectfully, all this court has to do is read the opinion of October 9th, 2020 and apply the law to what's being brought forward on this appeal. A little bit on the chronology of how we got here. While this first appeal was pending in 2020, my calendar informed me that the underlying judgment from circuit court was coming up on 10 years. And so we had to file a motion to renew that 2010 judgment. When that was filed, Judge Wagner in circuit court, who's a very conscientious jurist, looked at the docket and saw that there was a pending Rule 60 motion that the conservatorship, at that time it was a conservatorship, had filed in 2011 that had never been litigated. And so she asked counsel for both sides to brief that issue and had it heard. And as Mr. Wade alluded to earlier, ultimately she found that the reason she dismissed the appeal as to Barbara Pinson was simply because Barbara Pinson had not filed a notice of appeal, or not perfected an appeal, because she had never signed the notice of appeal. What that does, that means that by operation of law, the underlying FED judgment for possession in general sessions is reinstated as to Barbara Pinson. In other words, it is as though she simply never appealed the FED judgment for possession. So then the real question for this court becomes, what effect, if any, does that have on the ruling in the prior opinion? And I would submit that it has no effect. And in fact, this court's prior holding, the court adopted the rationale from a case called Love versus, it's Fannie Mae, Love versus Fannie Mae from Court of Appeals in 2015, which specifically said that a general sessions court has jurisdiction over an FED, and because of that, it was competent to consider title as a challenge to the seller's right to possession, which is what Judge Golden was alluding to in questioning. And this court specifically said in the 2020 opinion, and I quote, "Appellant could have raised the defense of fraudulent conveyance in the general sessions court and on appeal to the circuit court, but failed to do so." And so if the effect of Judge Wagner dismissing the circuit court appeal is to simply reinstate the general sessions judgment, this now reads, "Appellant could have raised the defense of fraudulent conveyance in the general sessions court, but failed to do so." And so I would submit that all this court has to do is simply follow the law of the case as was originally put forward in this 2020 opinion. The other thing that I wanted to respond to that Mr. Wharton mentioned was whether the issue was actually raised in general sessions. He mentioned that there was, I believe, I think it was styled as a motion to remove. There was a pending petition in probate court, if I remember the facts correctly, and there was a motion to remove from general sessions to probate. So whatever the result of that, if they raised it in general sessions, it's a matter that was litigated, and then that party failed to appeal to circuit court. If they didn't raise it in general sessions, it's a matter that could have been litigated, and res judicata applies in either event. That's all I have. Thank you.
Thank you. Mr. Ward.
5 minutes. Thank you, Judge. Your Honor, I'd be remiss if I didn't read the exact language just to respond briefly to opposing counsel's arguments. This is language from Your Honor's opinion in Ray Conservatorship of Cross. And this is a direct quote from the first opinion. Regardless of the jurisdictional constraints, and he's not Andre Warden, this is the court, this is the court's language. Regardless of the jurisdictional constraints of General Sessions Court, an appeal from General Sessions Court to Circuit Court is a de novo appeal. That's one. Subsequently in the opinion, the language is used. Accordingly, notwithstanding the limitations of General Sessions Court, a de novo appeal to Circuit Court provides the parties an entirely new trial as if no other trial had occurred and as if the case originated in the Circuit Court. What I submit, Your Honor, and the reason that's important, Your Honors, is that this court was acknowledging the General Sessions Court's jurisdiction is limited, whether we call it defense. And I submit this was not a foreclosure action. I know, Judge, you referred to the Chancery actions that are foreclosure actions, and you can raise this fraudulent conveyance as a defense. That is not what was going on here. This is an estate matter, and it was dealing with title. And it's
But it was
just,
an FED action, wasn't it?
well, yeah, it was filed as an FED action. That's correct, but it was not a foreclosure.
But I mean, it's the same principle would apply in an FED.
Yes, sir.
If somebody's trying to get you out and say, well, that's my house.
Correct. And you can raise it as a defense. But the question is that, and I submit the Ware case and these other cases I've cited, the General Sessions Court can consider it as a defense, but can they go ahead and then decide title? I think they can give possession, but they cannot engage in actions that Chancery or probate court would do. And I think that's what needs to be really.
How do you decide that then?
I'm sorry?
And how is that decided if the General Sessions Court can't consider it? I mean, what do you, that was what I was trying to say earlier.
Yes, sir.
Do you just stop, or?
I think
Can't you come in and prove your title? You say that's my property, and you come in and you prove your title?
I think you can do that, but still, at the end of the day, I think a court, if they're going to pass on a title action, I think that has to take place in another court. You can defend the possession issue, say, I don't have to get out of here because I have title, I have ownership. But in terms of that General Sessions Court actually saying, okay, I'm granting title to this person, I think the line is drawn there, and another court has to do that. And that's why this motion that was filed to remove should have gone to probate court. I think they're limited. I think a defense can be raised, yes, but in terms of going ahead and deciding, declaring who owns and ownership, that's not in the purview of General Sessions Court, is my argument. Let me just address this issue because Mr. Wade spent some time. I had to write it down because I was waiting for what he was going to say on that. I think he said he called this baseless, inequitable, and no factual basis. So I submit, Your Honor, the opinion that this court authored initially establishes ample basis for us to take this case before and use what the rules of civil procedure allow us to do, and that is a Rule 60 type relief, particularly to the extent that the circuit court, subsequent to this court's ruling, rendered a judgment that we were then entitled to rely upon to go back into probate court and say, hey, look, things have changed now. The circuit court posture of this case is no longer in existence, which this court recognized in its opinion. The language is, as far as this court is aware, this is language from Your Honor's opinion, as far as this court is aware, the Rule 60 has not been ruled upon. So I submit those are distinguishable, and I think pivotally distinguishable factors that allow and determine that this was appropriate for us to seek relief in the probate court again under Rule 60. Rule 60 speaks to this very kind of situation, and I submit this is a far from frivolous appeal, particularly when you look at the equity issue that I have not dealt with and I'd like to deal with now. This and Mr. Walter, and I refer to this, it's in the record. I think it's in volume 20, Your Honors. Mr. Walter was an administrator ad litem of the estate of Annette Cross, I believe. He was appointed as administrator ad litem. He's an attorney. And at one of the previous hearings, another hearing, when Mr. Wade, I think, and Mr. Townley asked for fees, Mr. Walter chimed in. And he said something I think stuck with me, and we cited it in our brief. It was so, I think, significant in this case. He says, I'll make it extremely brief. This whole case would not be here except for the illegal and unethical actions of Teresa Gibbs. That's the lady who sold her son. The only thing I wanted to say is that to reward the maker of the actions that created all this by paying her attorney's fees from the little money that's left from her illegal action seems to be patently unfair and unconscionable. That's not me arguing. That's the administrator ad litem. That's all I wanted to say. It's just as simple as that. So, in summary, the reason we're back here, Your Honors, obviously sounds in equity, but there are jurisdictional bases, I think, before you even get to the equity issue that I think are important. I think the court, I would ask respectfully the court look back at the opinion in Boyce and Love that Mr. Townley cited. They're distinguishable, especially when you look at the cases we've cited. And you're looking at Judge McGee's opinion. This court's opinion acknowledges the limitations. So I'm asking the court to distinguish, and I'm asking the court to reverse the trial court in this case.
Thank you very much.
Thank you.
Thank you, gentlemen.
Thank you, Judge.
May adjourn court.
All rise.